Good evening. This meeting will come to order. This is the September 2015 Zoning Board of Appeals. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, please.
Mr. Thomas has indicated that he cannot attend tonight. Mr. Tazzola?
Here.
Mr. Haberman?
Here.
Ms. Fronte? Here. Mr. Soda?
Here.
Mr. Vicino?
Here.
Mr. Dubois?
Here.
Ms. Eggleston?
Here.
Thank you.
Also present this evening is Stephen Harris, the zoning officer, and Meg Green, our recording secretary. If anyone feels that there's a member on this commission that might be a conflict of interest to their application, please let us know. With that, item number one.
Item number one, 990 Naugatuck Avenue, HDD, Brian Stone Esquire, for the Housatonic Terminal LLC appellant, Recycling Inc. owners. Section 9-2-1, appealed the decision of the zoning enforcement officer on 22nd of May 2015, map 40, block 300, parcel 2.
Good evening, Mr. Chairman, members of the commission.
I just wanted to note that this is a continuance of a previous of a hearing that was brought before the board previously.
Yes, yes, this is a continuation of a hearing that was
Correct.
back in July. The July meeting was continued last month, and so this is the second evening of this hearing. Thank you. For the record, Mr. Chairman, members of the commission, I am Attorney Brian Stone from the Pellegrino Law Firm, and I represent the applicant, Housatonic Terminal LLC. With me tonight is Joseph Barrett, who was also here at our last meeting. He's a member of Housatonic Terminal LLC and one of the original owners of the property going back to 1955. Also with me is James Barrett. That's Joe's nephew. His father is one of Joe's brothers who also is an owner of the property, and he also happens to be the president of East Coast Demolition Company, which was referred to, if you recall, at the last hearing as one of the Barrett companies that did demolition and recycling on the site, which is the subject of this hearing. I'm going to try not to be repetitive of the last hearing, and if I am, please feel free to say I'm being repetitive and move on, and I will do that. What I would like to do that I did not do at the last hearing, and in part in light of the change in the cease and desist and the desire to present more evidence for this evening, is to kind of go through the history of this site a little bit. This will be a little repetitive at the beginning, but again, as Joe Barrett testified, he and his brothers acquired the property in 1955. They had numerous family businesses which they operated out of that property, one of which was East Coast Demolition Corporation. That corporation was founded in 1950. It was actually, the company was started in 1950. It was incorporated in 1956 and operated from the time they purchased the property out of this property, along with Barrett Brothers Builders and some other entities. East Coast Demolition was important to this particular hearing because they demolished buildings and then brought back the materials to be, as Mr. Barrett referred to, as salvage, as we refer to today, as recycling the building products, including steel, brick, fixtures, all types of building and construction materials, which were sold from that site for over 40 years. The business of the East Coast terminated in 1995. It didn't terminate by choice. It didn't terminate to change the operation on that particular site. It was an economic downturn, and as a result of that, East Coast went out of business at that time. It was, as Mr. Barrett testified, always their desire to retain that use and at some point to restore that, and you'll hear testimony regarding that today. And in fact, East Coast was finally started up again subsequent to the sale of the property in 2011, and Mr. James Barrett, who was the impetus for trying to get it, one of the impetuses for trying to get that business restarted, is the president of that company today. The property did not recycle for a period of time, and that was from 1995, 96 till about 2004. In 2004, the property was leased to Coastal Recycling, Inc. A notice of that lease was filed on the land records. I'm going to submit as an exhibit a copy of that. Now, Coastal Recycling operated a recycling facility on that property. It did not have any permits. It was an unpermitted use, but it operated there for a couple of years. Then that business was terminated. In 2006, the property was leased to Recycling Inc. And Recycling Inc. applied to the state for a volume reduction facility in 2007 and acquired that in 2008, December of 2008. It applied to the Planning and Zoning Commission at that time for a special permit under the regulations in the HDD zone, which allowed for recycling facilities in 2008. The history of that, I think, is embarrassing, frankly, that application. But what I'd like to do is submit a copy of the transcript of that public hearing, which was held in 2009 on the application for a recycling facility to the Planning and Zoning Commission. At the time this application was attempted to be filed, wasn't accepted. You can read the history of that if you review that transcript. And during the pendency of the attempts to file that application, which ultimately was accepted because it was delivered to the mayor's office, the Planning and Zoning Commission amended Section 12.5.3 of the zoning regulations to prohibit recycling in the Housatonic Design District. That the decision was to deny that application, and frankly, that application need not have been filed, as was subsequently proved in a case brought by Recycling Inc. against the town of the city of Milford, and Judge Hiller. It was a declaratory judgment action to rule that the regulations were not valid and that the state had preempted the field for recycling, with the exception of landfills. And I'm going to submit a copy of Judge Hiller's decision as an exhibit as well. Now, the history of the Solid Waste Act is kind of interesting. In 1985, the act was amended to give municipalities jurisdiction, zoning jurisdiction over solid waste facilities. In 2006, the act was amended to take that away. So when I say that there was really no need to seek that special permit, and the reason for that is, as is found in Judge Hiller's decision, that in 2006, the legislature made a decision to eliminate the right of municipalities to make decisions regarding solid waste facilities, with the exception of landfills. Landfills have always been subject to municipal jurisdiction. That was not the case with respect to what a recycling facility, or in this case, a volume reduction facility, which was what Recycling Inc. had applied for. So there was a permit that had been issued in 2008, and recycling went into operation subsequent to Judge Hiller's 2010 decision, and operated a recycling facility under that permit. In 2012, something interesting happened. The legislature amended the act again to provide for some municipal rights with respect to solid waste facilities. I'll submit a copy of that amendment. This is a copy of the public act, and what it shows is how it read before and how it reads now. What you'll see is this is Public Act 12-2. It was enacted on March 6, 2012, and it was brought before the legislature by Milford State Senator, Senator Schlossberg, who I will say that whether you agree or disagree with her positions, you have to admire the fact that her vision of what's good for the city of Milford, she does a remarkable job of getting things passed in the legislature. The change in subsection B to this statute, which reads, "Nothing in this chapter or chapter 446E shall be construed to limit the right of a municipality to regulate through zoning land usage for an existing or new solid waste facility. No municipal regulation adopted pursuant to Section 8-2 shall have the effect of prohibiting the construction, alteration, or operation of solid waste facilities within the limit of a municipality." So what happened was there was a couple-of-year period where Milford, or any other municipality did not have the power to regulate solid waste facilities. In 2012, that right came back, despite the fact that the original rationale was that municipal regulation was preventing the creation of solid waste facilities, which was why it had been changed back in 2006 in the first instance. But without editorializing on that reason, for a period of time, this facility was operated legally. And so I submit that, and this is rather more of an aside, that the original decision of the zoning enforcement officer is accurate, because that was a validly operating facility. When it became non-conforming by the enactment of new legislation, it was still in operation, and so that was still a valid non-conforming facility. But that's really not the primary purpose for my being here, as I explained to you last time. The primary purpose is to establish that this has been a valid non-conforming use going back to 1955. And why do we want to establish that? For the very reason that we don't want to go through again what was gone through in 2009, and I beseech you to read that transcript to see why we think that we should be allowed to obtain a state permit for the operation of this facility. Now, the reason that the zoning enforcement officer changed his opinion is because the permit that had been issued was revoked by the Department of Environmental Protection. This happened in 2014. And I'm not going to give you the whole decision. I'm just going to give you some of the decision, pages 40 through 42, which talks about some of the non-compliance with the act. If you read it, it's not pretty. And we're not claiming that Recycling Inc.'s performance was in any ways exemplary in this process. But what it does show is that, in fact, a recycling facility was in operation on the site, and so that's the purpose of this submission, not certainly to make Recycling Inc. look like it's a good guy. So, going back, and one thing you should know, there had been a fire at this site, and you'll hear from that from Mr. Barrett when he talks about how the site differs today from what it used to. And so a lot of records were destroyed, so you had asked if we had any documentation. What I would like to submit is two exhibits. The first is the application for the renewal of East Coast demolition permit to the state. It has an application form, a cover letter, which the cover letter has some background, but attached to it are a bunch of demolition permits. These are from the city of Bridgeport. Certainly not all, but a fair percentage of East Coast demolition, which was all brought back to this site, was done in Bridgeport. And so the records were obtained from Bridgeport to the extent they were available. And these have permits. It's not, this list is a list from the town, from the city of Bridgeport. It has demolition permits listed to a number of demolition contractors, but East Coast is in here going back to 1959 in this list, and some 78 permits over that course of time. The second is I had subpoenaed records from the building department for demolition, additional demolition permits, that they had a record, a list of permits. That was what could not be gotten for the meeting last time, because I guess they were in archives. They're rather old, and the archivist only works like once every 2 months or something like that. So we had difficulty obtaining those records, but I do have those. You'll see I'm going to submit a copy of my subpoena as well. You'll see on the cover of the subpoena, there's some handwritten marks that was done by either the building official or the archivist to indicate what they could find and what they couldn't find. Some they found, some they didn't. What's the purpose of this? Well, the purpose of this is to corroborate what Joe Barrett testified to at the last public hearing relative to the operation and the time of the operation of East Coast Builders on the site. Also in the first of those two exhibits, the application to the state for renewal, that was in 2011, you'll see the incorporation papers for East Coast Builders going back to 1956. Now, I have a number of additional exhibits consisting of pictures and some drawings, but I'd like to call Joe Barrett up, who obviously has the historical perspective with respect to the site, and he can describe those pictures. The first is a set of pictures of demolition, and he can describe them. I'll hand them out, and then I'll ask that he come up and then describe the pictures that you're looking at.
Mr. Stone, let's see if we have any questions so far.
Sure.
For you. Any questions? Any questions so far for Mr. Stone? No? Okay. Mr. Barrett. Mr. Stone,
Yes.
we have a question for you.
Mr. Stone, you earlier said that East Coast ceased operations in 1995, is that correct?
That's correct.
Okay. Well, on the second page of this, it says, "All demolition permits issued from 1/1/97 to present, East Coast Demolitions."
Well, there wouldn't have, yes.
I mean, that's just on what you just gave us.
I asked that.
You asked that too?
I asked for that from Bridgeport, but there aren't any.
So they were in business after 95?
No,
Or
no,
this
they
is
weren't.
wrong?
No, they were not in business after 95.
Okay. So this date's wrong?
No, the request is accurate. I asked for any that existed, knowing that I would receive nothing back.
Oh, okay.
Okay. I mean, that's the subpoena.
Yeah.
Okay. Joe, could you describe this exhibit, which is appearance of... a series of 6 pictures. Could you describe what those pictures represent and when they were from?
The board has copies of all these?
They have copies.
Yeah. The first picture is taken in Bridgeport. That was the former Jewish Community Center, that particular building. And you can see that there's a 60-inch I-beam, which we took and stored along the river.
Mr. Barrett, would you please pull that microphone up just as close as you can to talk into it, please? Lift the microphone up a little bit more, please, so we can hear you very clearly.
Is that better?
That's great, thank you.
Sorry about that. Yeah, that picture is on the Jewish Community Center in Lafayette and State, Bridgeport. That'd be on the northeast corner. That was a good-sized building, a lot of steel in that building. We salvaged all of that, plus the fixtures and all. And in the picture is my younger brother, has been deceased now for 10 years. The operator, that was a hell of an operator he was. He's deceased now, Paul Hurd, great football player when he was in school. That was myself was next, and then 2 other gentlemen. One was a superintendent, Chris Ruther, he's deceased, and Mo Mosier, he lived right here in Milford, and he's been deceased. So I guess I got the lucky star that time. And the second picture is right across the street. That's the old Time Star building. I don't know if remember the newspaper. There was a Time Star and a Herald, and that was right across the street from the Jewish Community Center, and that would have been on the south east side of Lafayette and State. Next to that building, we took all the buildings down from there all the way to Broad Street. And the only thing left on the Broad Street was the library, which is still there today. The building right next to where the crane is to the left side of it, that was the old Majestic Theater. Beautiful, beautiful building. All kinds of salvage out of that. And that was brought over to 990. The third picture is between State, Broad, and Lafayette. All the buildings came down except the one you see directly in back of it, and that still stands today. That's not Lafayette, it's a medical building. They, for some reason, convinced the town that it was structurally sound and they were going to make some improvements, so they kept that. So the next picture is a backhoe, and yours truly was operating it. And that back of the building is the old, I say old, it was where the Algonquin Club, it was a gentleman's club. They served dinners, and accountants, attorneys, and businessmen, they used to go there for luncheon days. That's that building. And we were fortunate enough to, in the construction division of ours, we won the contract after we took the buildings down to rebuild all of the infrastructure underground and above ground, and that was part of the job today. In fact, that fellow that was standing there, Richie Moyer, his name was, he just passed away here just a few months ago. And the last picture was the old Buffalo roller, and that was on Lafayette, and the building in back of it was the luncheonette. Mr. Marchetti, Tato Marchetti used to run that. In fact, his nephew, when he graduated from Stratford High School, my younger brother, and he became a representative for Goodyear Golf goods and things like that. And that we were rebuilding that Lafayette Street along with State, Broad, John, so a couple other side streets. I can't recall the names right now, but that was the construction division of ours that was doing that work. Brings back a lot of memories. That's all the pictures I got.
Yeah, Mr. Barrett, was the demolition from all these buildings that you took down, did it go back to 990 for
Yes, yeah.
for
All this-
recycling or what you call salvage?
Yeah, all the steel beams, all of the sinks, toilets, fixtures, brass, copper. We brought all that back, and we stored the fixtures and stuff into the warehouse. I don't know if you got a picture of that. And Saturdays was the big day for the homeowners come down and they'd buy different fixtures and stuff out of the warehouse.
Mr. Chairman, while Mr. Barrett was just speaking, I just handed out another exhibit. You'll see at the top, it's marked 1956, and this is an aerial photograph of the site from 1956. And I'd like to ask Mr. Barrett to describe what's in this picture and what the operation was at that time.
Yeah, you can see the former office warehouse building near the water. It's next to the barge. The barge was unloading oil into the oil tanks. At that time we had a contract with Gulf Oil, and when that lapsed, we had a contract with Shell Oil, and then we had a contract with Copper's Coke for the heavier oil, for the asphalt to make blacktop. And that barge was offloading. The crane, the barge-mounted crane, further out in the water, they were using our dock when they were replacing the fenders on the railroad bridge south down the stream next to I-95. That's what that's all about there. And we used to store, if you look at the picture, on the left side, as you're looking at the picture, it would be on the west side of the property along the river.
You have a picture that shows the storage, so.
Oh, okay.
I'd have to
Okay.
just describe it.
In this picture, we demolished and did away with 3 tanks up along the railroad. The 3 larger tanks. The one smaller tank is we call 101. We used to store gasoline in that for all the fleet, the gasoline-driven vehicles. The tank alongside it would be on the right side of your picture, looking at your picture. That's what we call 108. We moved that tank down and encompassed it with the 3 that you see in back of the boiler house, the boiler room. That's the building with the white top, and you'll see the chimney coming out of it. We moved that and consolidated those. The brick building in the back we use for maintenance of all of Barrett's equipment, East Coast Demolition, Barrett, D&J Quarry, all of the subsidiaries to Barrett. All the maintenance was done on that building. I don't know if you can see the 4 horizontal tanks there. They were the working tanks. We used to pump the oil out of the larger tanks into the operating tanks, and then from there, just to the right of it, would be the loading rack where the Aaron's and Chico and a multitude of others used to come in and fuel up there. We used to sell wholesale oil. I don't know what else I could bring up.
I had mentioned a fire. Could you describe the fire on the site? Fire. There was a fire on the site?
Yeah, the office building somehow mysteriously got caught on fire. To this day, no one ever knows who did it or how it happened or anything else. It's maybe it was an act of God, I don't know. But that's no longer there. The garage is in need of repair. It needs a new roof. Other than that, she's pretty much, the only thing you don't see in this picture is on the north side of the property, there's an adjoining 2 acres that we acquired from Eddie and Dan Carton. When they stopped business, we acquired two additional acres, about 2-point-some acres there. And that was also used for storage, both equipment and East Coast demolition materials.
Okay. Have there been any additions to this site? There have been removals of things, some oil tanks, as you described.
Right.
The building burned down.
Right.
The office building. Has there been any additions on this particular site that shows on the map? Have any of the areas where you stored material or anything been
Other than
changed?
the 2 acres that we bought from Carton, that's on the north side of the property.
Okay.
It's not, it doesn't show on that picture.
Mr. Chairman, the exhibit I just handed out is a copy of that aerial photograph that Mr. Barrett just was describing, and you'll see highlighted in blue areas of the site. I asked Mr. Barrett to identify the areas where the material that he recycled were kept on the site, and he identified those areas, and I, to the best of my ability, colored them in. And Mr. Barrett, does this accurately depict those storage areas for recyclable materials?
Yes, it does. Yes, it does. There's one addition, the former warehouse/office space. We used to store all of the fixtures and things that we didn't want to wander away inside that building on the north side of the former office warehouse building, which burnt down. We should have highlighted that earlier. I forgot about that. But that's it, yeah. All the heavy steel went along the river. I say heavy, all along. Anything from 20 feet on up to 60 feet, we used to store along the river. All the smaller beams and stuff, we used to store up as you come into the driveway, up along the railroad tracks. All beams 20 foot or less. That's what I got up there. Brick and granite stone and flagstone from the different buildings. We used to store on the north side where you see it all outlined in green. We didn't have much. The only lumber we saved was the yellow pine and oak. That's the only thing that we saved, and we used a lot of that in Barrett's construction division for shoring and underground protection and things like that. So it was kind of handy to have that around. I don't know what else I could point out.
Mr. Barrett, obviously you had to bring all this material in.
Oh, yeah. Yeah.
And could you just describe the access route and
Yeah, well,
the driveways?
Well, we came in off of Naugatuck Avenue, down across the right-of-way, across the railroad, and it would be on the south side of the property. We'd drive down in and we come right around and where the longer steel would go, and so on and so forth. And we'd have a machine there that offloaded it, and a yard man there all the time, keeping things in order, so to speak. And we had a back gate that we sometimes used to bring longer pieces in, so because it had more room to maneuver. But the majority of it came in on the south driveway across the tracks.
And did you process and resell this material?
Oh, yeah, yeah. In fact, we had some good luck, and the price of steel went up, and all our steel, all our I-beams, all the metals and stuff all went to Rubino's down in Stanford, and they shipped the barge up, and we loaded all the steel on, and that went to Elizabethport, New Jersey, and then was loaded on a freighter and went to Italy, to Schiavone Bonomo, the world's largest scrap dealer. That's where all the steel went. We kept the smaller stuff because Barrett was using those in the construction jobs. But the longer beams, and they were, up to 60-foot length, some of them, they were all shipped out and recycled and went to the Rubino Brothers in Stamford, Connecticut, by barge.
Thank you. Is there any questions for Mr. Barrett?
Yes, I have a question for Mr. Barrett. Mr. Barrett. Mr. Barrett.
Yes.
This operation started in 1955, and as described by your pictures and what had been going on with this operation, when would you estimate was the last really heavy years of your operation? Do you have any idea when that might have been?
I retired in '85. My younger brother, that's been deceased, he ran the operation until, let me see, I think it was 94, 95. That was the last time he operated out of there, out of 990.
All right, so you said you retired in '85, and after you retired, would you say that operation was still going, but it was like, he had mentioned, Mr. Stone had mentioned that some activity had taken place, but no permits were ever done. So it was like the operation was there, but we didn't even know about it.
I couldn't understand what you said.
My question was,
If I can.
Go ahead.
Just
Go ahead.
just to correct your characterization of my statement. What I said is in 2004, it was leased and operated at that point as a recycling facility. There was a period between 95 and 2004 when it was not. The tenant who leased the property did not get permits from the state to operate that facility, and so it was an unpermitted operation, an operation nonetheless. So that was a statement, which is why I think Mr. Barrett's a little confused.
so there was 9 years of operation there that
Eight to-
technically
eight
no
to-
one even recognized that it was going on there. It was going on, but we didn't know.
Well, it was clearly
about it.
recognized. There were cease and desist orders and whatnot issued, so yes.
Thank you. Any other questions for Mr. Barrett? No? Okay. Is there anyone else speaking on this appeal here?
Yes, James Barrett.
Hello?
State your name and
Mr. Barrett.
James Barrett.
Please identify
Yeah,
yourself.
James Richard Barrett,
And your address, please.
61 Taylor Road, Bethel, Connecticut.
And could you describe your relationship to Barrett as a Barrett? family member?
My father is the eldest of the three brothers and was over in 990 Naugatuck until I believe it was December of 1969 when he retired. The three brothers ran, East Coast, JF. It was a playground for all the kids. The demolition, I mean, every summer was nothing on ball fields or playgrounds. It was going to work with Dad. I've got, all types of memories and recollections of sitting on machines with all the guys and riding back and forth from Bridgeport or wherever they were doing the work back to the yard. Just a constant playground. I remember getting in trouble over in the terminal, like running through the warehouse and breaking mirrors and toilet seats, and it was a wonderland for all the kids.
Could you describe the demolition and recycling operation at the site?
Well, it was like my uncle had basically pointed out. Here again, I was a very young lad, but we would go from running the crane to getting in the trailer dumps to bringing it back to the yard to pretending, I guess, I was helping to unload the material and sort the material. We had all types of little mini buggies that we had all, the kids would get in and drive around the yard to, pretend we were helping. But it was a very unique piece of property. There was always something going on.
Okay, any questions for Mr. Barrett?
Excuse me, I just have another question for Mr. Barrett. Mr. Barrett, could you, do you recall when the recycling operation terminated?
It was basically when my Uncle Don died, which was 95-ish. I know my cousin, Keith and Kevin, hung on to the license, and I know that they were doing some small demo at the time after that. But that's about it. I really didn't have, there was a lot of family bad blood, not between my uncle and myself, but between my other cousins and myself.
And did you have any discussions about renewing the demolition and recycling operation at the site?
I've been after my uncle since he retired to get back into doing something. Demolition like be number one. And here, just a short while ago, 4 years ago, I guess it was, we, finally convinced him that we should, resurrect and do something. It's just a shame to let it go. Class A license is awfully hard to come by these days.
Nothing further.
Any questions? Okay, is there anyone else speaking on this appeal?
Just one legal comment I'd like to make in wrapping up. If you look at the statute that talks about the amendment to the statute that talks about the regulations can't preclude recycling facilities, I think your regulations and the manner of their enforcement does just that. First of all, it's a special permit. It's not a permitted use, which means that it gives the Planning and Zoning Commission discretion with no standards, and therefore, essentially, I believe that to that extent, that the state statute preempts the regulations as they exist today. And that's something that we certainly will continue to pursue. But here today, we're appealing the zoning enforcement officer's decision because we think we have an ongoing and continuous non-conforming use at the site. Thank you.
Thank you. Mr. Harris?
Good evening, Stephen Harris, Milford Zoning Enforcement Officer. last time Mr. Stone talked about a lot of past uses that he alleged had gone on at this site. And they were recycling, sorting and selling of scrap metal, heavy trucking, manufacturing plant, heavy equipment, industrial, cranes, dozers and drills and so forth, and the sale of light and heavy oil. When someone makes a claim of a non-conforming use, it is the burden of the owner to prove that those uses existed in the first place. Mr. Stone has not submitted any hard evidence that any of those uses listed in number 1, A through F on my handout ever existed in the first place. But if they did, then the applicant also has the burden to demonstrate that they are taking all reasonable efforts to continue those uses. The language of the regulation 6.2.7.1 reads, "The term abandonment as used herein shall mean the voluntary discontinuance of a use when accompanied by an intent not to reestablish such use. Any one of the following shall constitute prima facie evidence of intent to abandon." And it mentions any failure to take all necessary steps to resume the nonconforming use with reasonable dispatch in the circumstances, including advertising of the property for sale or for lease. Mr. Stone has not submitted any hard evidence in the way of real estate advertising or any kind of advertising or bills of lading or anything to demonstrate that all of those uses in A through F have been actively marketed as such. The last information we have is a demolition permit from 1996, and we have nothing on any of the other uses. So it's the city's position that those uses, if they were ever there in the first place, have been abandoned because it doesn't meet the regulations 6.2.7.1. So therefore, I would respectfully ask the board to deny Mr. Stone's appeal.
Any questions for Mr. Harris? Thank you, Mr. Harris.
I believe Ms. Suchins will have something to say.
Is that okay? Okay. My name is Amy Suchins. I'm an attorney at Hurwitz, Sagarin, Schlossberg, and Nuff. Our office has been serving as outside counsel to the City of Milford in connection with both a number of the pieces of the ongoing litigation with 990 Naugatuck and Recycling Inc., including the proceedings that were before DEEP in 2013 and ongoing in the Superior Court, as well as a separate action that's been brought, excuse me, and currently held in abeyance about the validity of the statutory amendment that Mr. Stone mentioned. I just want to highlight a few things based on Attorney Stone's comments. I think a number of the things he's raised and Mr. Harris pointed out, frankly, undermine Mr. Stone's very argument. In fact, what is in existence right now is that there is no valid legal ability for an applicant to operate a limited processing recycling facility at 990 Naugatuck. The general permit not only has been revoked by the Department of Environmental Protection, that has also expired on its own terms. Included in the application materials is a copy of the permit registration, and I'd like to give you a copy of the general permit itself, which notes that the general permit did expire last month, and in order to legally operate any kind of limited processing recycling facility, a new applicant would have to re-register under those terms. So. So as you notice, this is a copy of the general permit to operate certain recycling facilities in the state of Connecticut. This was the general permit that had been the basis for which, or on which, Recycling Inc. had been operating on the premises. As you can see on its face, the expiration date was August 15th, 2015. The other point that I wanted to make to you about the general permit is that Attorney Stone has mentioned on a number of occasions that they are here very explicitly because they want to reestablish and reapply for a volume reduction facility on this property. Part of that was based on Mr. Barrett's testimony at the last hearing, where he indicated that he had never had any kind of limitation on the amount of recycling he could do. In fact, the general permit itself, by its very terms, limits the nature of the operation that he could have, or Recycling Inc. could have operated. If you look at page 7 of 43, they're numbered at the bottom. There is a set of definitions, and a limited processing recycling facility means a solid waste facility where source-separated solid waste or commingled recyclables are collected and sorted or processed, and where no more than 20 tons of such waste is accepted each day. So the general permit registration, by its very terms, and to the extent that there's been testimony about what has happened well before 1995, what's in the record before DEEP, what's noted in the registration that was part of the application, was that the initial registration under this type of general permit for limited recycling was issued in 1984. So certainly, to the extent that we've heard testimony tonight that there was recycling through 1995, they've submitted no evidence to demonstrate that they did not have this limitation. If you turn to page 11, about midway down through the page is the definition of a volume reduction plant, which means any location or structure, whether located on land or water, where no more than 2,000 pounds per hour of solid waste generated elsewhere may be reduced in volume, including but not limited to, and defines a number of facilities. So by its very terms, a volume reduction plant allows an unlimited amount of quantity, basically whatever you can accommodate on the site or what DEEP would allow. So it would be a substantial increase over any argument that they had about what they were operating under the previously valid general permit registration. To the extent that that's relevant to your considerations, what Mr. Stone is asking for is for you to sanction an expansion of a non-conforming use. Even if there was evidence before you tonight, and I don't think there is, I think it's been very clear, particularly with the statements tonight, that any recycling by the Barretts came to an end in approximately 1995, that even if it was non-conforming and legally non-conforming, that has, what they're trying to do is to expand that operation to accommodate an application for a volume reduction facility, and I don't think there is anything that they've presented here that would support that. Certainly, there's been no evidence that they had operated as volume reduction facility. That would require an entirely different permit from the general permit registration. It's a separate, what's called an individual permit from DEEP, and it's reviewed for that limited purpose only. It's not simply a registration, which is basically just a notification to the state and some reporting requirements. It's a separate application akin to what you might see for a variance or that kind of thing, where a commission or the department is reviewing that application individually. To the extent that Attorney Stone did mention at the last hearing he didn't know the status of that volume reduction application, it is part of the application that was denied by DEEP, so there is no currently pending or held in abeyance application. That application for a volume reduction facility was denied by DEEP as part of the same hearing at which the general permit was revoked. I think the last point that I wanted to emphasize was that to the extent that What Mr. Stone and Mr. Barrett have attempted to do tonight is to demonstrate that there's been no abandonment of a non-conforming use. I think the fundamental shortcoming here is that by their own testimony, they stopped operations in 1995. By their own testimony and the evidence in the record, including in the application, indicating that Recycling Inc. Is and remains the owner of the property. There's been no evidence presented to you that demonstrates that Recycling Inc. did not intend to abandon its use. In fact, the deep regulations prohibit you from having a general permit registration if you were to have an individual permit for a volume reduction facility. So in essence, they are abandoning the smaller option in order to go to a larger one. Regardless of that, there's still no evidence for any of the uses that are outlined in their application materials, and there were several, I think 6 or 7, including some of the heavy industrial uses that they cited, that those had not been abandoned by Recycling Inc. during its ownership of the property. Certainly, if there's a legal non-conforming use that had been continued through the hearing, through the change in ownership, that would remain valid and would continue as a valid non-conforming use, but they have not demonstrated any of that. There's been no showing that during the period from when Recycling Inc. owned the property in 2009, or even in the last 2 or 3 years since the issues at Deep have arisen with the misrepresentation, that they have intended to maintain any of those into any of those uses. So in the absence of that, the fact that there has been such an extensive break, clearly it needs to be a finding of abandonment, because there's nothing to show that show this board that there has been an intent to maintain that use. I think the last point that is important for the agency to also consider is, quite honestly, that I'm concerned that there continues to be misrepresentation in the application that has been presented to you. At the last hearing, Mr. Barrett was represented himself to be the sole principal and sole member of Housatonic Terminal, LLC. He indicated that he took back a mortgage when Recycling Inc. put when they acquired the property, and that as a result of a forbearance agreement, he is hoping to pay off his mortgage and have that mortgage paid off and put the property back into economically viable use. Unfortunately, that's not quite the whole story. There are a series of mortgages on this property. The hearing officer before Deep, and I will submit just one copy of all of them for the record, heard evidence that during the tenure of Recycling Inc., approximately $4.5 million worth of mortgages have been placed on the property. Property's estimated value is about $1.8 million. Mr. Barrett's mortgage, at least as of about a year ago, was about $2 million on its face. So certainly there is a large question as to whether or not all of those mortgages could in fact be released. The testimony, again, before the hearing officer at Deep was that those mortgages, most of which are controlled by Mr. Gus Curcio, would never be released unless he was repaid. I will submit also for you a copy of the complete proposed final decision from the hearing officer, which documents that testimony and also documents the fact that Recycling Inc. was actually set up at the direction of Mr. Curcio by Mr. James Barrett, who had just testified here and was not aware of, despite the fact that he served as its Recycling Inc.'s initial president, was not aware of its operations or had any involvement in its control. So I just want to make you aware of that in your process. I think the other important point that I want to point out is that to the extent that Mr. Barrett is in fact trying to reacquire the property, the city of Milford, through the city attorney's office, has in fact obtained a judgment of strict foreclosure on the property if the back taxes totaling approximately $340,000, just under, are not paid by February, the city of Milford will acquire the title to the property. Certainly, there's been no evidence presented that if Mr. Barrett is intending to make productive use of this property, that he has the wherewithal or ability to redeem that judgment. So let me put these into the record. I think the last point, just in conclusion, Attorney Stone was very clear at the July 14th hearing that the purpose of this proceeding was to reestablish the nonconforming use that had been in existence for 50-odd years. The fact that he used the term reestablish undermines the fact that this has been a continuous use of the property that has not been abandoned. Merriam-Webster defines establish as to begin or create something that is meant to last for a long time. The prefix re means, again, back to an original place or condition. So if you need to reestablish something, it necessarily entails the fact that it has stopped or has come to a conclusion or been interrupted. You've seen no evidence presented to you tonight to demonstrate that since the Barretts left the property by their own terms in 1995 and stopped recycling, that there has been any intent to document and maintain all of the uses that they've requested in their appeal. As Mr. Harris noted, the burden of proof is on them, and I would respectfully submit that they have not met that burden. If you have any questions for me, I'm happy to answer.
Any questions? Thank you.
Okay.
Anyone else speaking on this appeal? Mr. Stone, you can have the last word.
I'll be brief. As far as evidence concerning listing of the property, we have the testimony of Mr. Barrett from the last meeting. You are the judges of the credibility of the witnesses. I think Mr. Barrett's been very forthright before you. Abandonment, the question of abandonment of a non-conforming use is a question of intent. And I think that there's been plenty of evidence to suggest that there has not been an intent to abandon this particular use. Was it stopped for a while? Absolutely. Reestablish, my word. An interesting bit of wordsmithing by Attorney Suchins, but the reality is it's a non-conforming use of the property. It's a valid non-conforming use of the property. It has not been in operation, but it has not been abandoned, and that's the definition of a valid non-conforming use. As far as recycling Inc., I agree with Attorney Suchins that their intent is important as the owner of the property, but I think she's being a little disingenuous since she is party, her law firm is party to an appeal that was taken from the DEP's termination. I only have one copy of that because it's my only copy. I wasn't planning to submit it, but in rebuttal I'm going to submit a copy of the appeal taken by Recycling Inc. of the revoking of their permit and the denial of their volume reduction facility permit. With respect to the economics, we're hoping that a proper decision will allow the economics to work themselves out. But we are not Recycling Inc. My client is not Recycling Inc. And we are looking to reacquire the property under an agreement that, a forbearance agreement that is really not relevant to this particular proceeding for determination of whether it's a non-conforming use. Thank you.
Any questions for Mr. Stone? None? Okay, this hearing's closed. Discussion? Your thoughts? Well, they had a big operation once upon a time, but again, we got up to 1995. We had some speculation on what went on from 85 to even 95. So there's really, again, it's proof of operation. Mr. Soda.
Well, by their own testimony, they're saying there was no use from 95 to 04. I mean, that's 9 years.
Any other thoughts?
There's a lapse in use. There's no real evidence, hard evidence to show that they continue to use, and they can't acquire a permit if they wanted to legally. So I think that says it all right there.
Okay, if there's no more discussion, we need a motion.
Make a motion to uphold the decision of the zoning enforcement officer, deny the appeal.
Second. We have a motion to uphold the zoning officer's decision on the appeal. And we have a second on the motion. Mr. Soda.
With the motion.
Mr. Vecino.
With the motion.
Mr. Habman.
With the motion.
Ms. Ferranti.
With the motion.
I'm with the motion. Zoning officer's decision is upheld.
On the second one?
We're going to have about a 5 minutes recess. All right, we're back. Item number 2.
Item number 2, 1718 Boston Post Road, CDD5, Joseph Del Vecchio, appellant, Section 9.2.1, appealed the decision of the Director of Permitting and Land Use for reversing an enforcement order to cease and desist use of refrigeration trailer for storage. Map 109, Block 804, Parcel 12.
Good evening.
Hello and good evening. My name is Joe Del Vecchio, and I live at 275 Sarah Circle in Orange with my wife and 3 kids. I'm here tonight on behalf of my family as well as my neighbors, some of who are here tonight. With me I have John Corker of 281 Sarah Circle and George Poland of 287 Sarah Circle. For many years now, Costco has adopted the use of external refrigeration trucks and trailers at their loading docks as a means to increase their storage capacity for their store. They will regularly leave these external refrigeration trucks running for hours, days, even weeks on end. They'll run all night long on holidays whenever they have a need for more refrigerated storage space than they can presumably fit inside their store. I brought this to Costco's attention multiple times and tried to work with them to resolve the situation, but with no resolution, I brought my complaint to Stephen Harris in the zoning department. Stephen performed a site visit and determined that Costco was in violation of Milford zoning regulations. He documented the violation and issued an enforcement order on May 16, 2014. I believe you may all have a copy of that, as I included that with my application. Costco failed to comply with the order, so once again I brought this to Stephen's attention. He noted that he had done all he could do at that time, and that this would now have to get pushed to the city attorney's office for them to pursue it. I contacted the attorney's office. I actually went down there to see them, and was informed that Costco had already called and stated that they had resolved the issue and there was no longer refrigeration trucks running. That was the case, but that was just for that day. This, of course, was not true, and shortly after that time, I contacted the attorney's office again to inform them that they were doing this again, operating these trailers. On June 16, 2014, the city attorney's office issued a letter suggesting that the town of Milford would initiate enforcement if they did not comply with the violation. You should also have a copy of that letter in my application. Costco still chose not to comply with the order, so I was forced to contact the city attorney's office once again. After approximately a half dozen unreturned calls, which began on around May of this year, Stephen Harris contacted me on July 3rd, 2014. Stephen Harris contacted me to let me know that on July 3rd, 2014, Joseph Griffith, the Director of Permitting and Land Use, arbitrarily and without explanation determined that Costco appeared to be in compliance with the approved site plan and Milford zoning regulations. I've attached a copy of that email as well. This decision was made despite having his own zoning enforcement officer's letter, documentation, and decision regarding the issue at hand. Joseph Griffith offered no verifiable explanation when he made this decision. Stephen Harris did when he created his enforcement order. This still remains an ongoing and disturbing issue, and I'm respectfully requesting that Joseph Griffith's decision be reversed back to that of the town of Milford's zoning enforcement officer's original enforcement officer. I'm asking that this please be done immediately and enforced to the fullest extent possible. I believe it's important to be clear on this issue, that this has nothing to do with refrigeration delivery trucks entering Costco's property and making deliveries and being unloaded on a timely basis. This is a deliberate and prolonged use of these trailers as a new means for Costco to increase their storage. We completely understand that refrigerated trucks come in there with food and whatever it may be, and it needs to be refrigerated. We get that. This issue is parking these trailers there whenever they feel the need. They can be there 24 hours, 2 weeks, and they don't care. The last thing I'd like to mention is that it should be noted that in the Milford zoning regulations, Article 8, Section 8.2, zoning enforcement officers, it does not list the Director of Permitting and Land Use as someone who has the authority to enforce the provisions of these regulations. Thank you.
Okay, again, what was the date that you learned of Director Griffith's emailing that the trailer was in compliance to the zoning regulation? Was that, I think you might have said it might have been when, around June 16th?
Yes.
Okay. We're surprised to hear, listening to you, that Costco was not a very good neighbor. You would think, I don't know how many, you said you contacted them several times and they didn't do anything for you. So it's unfortunate that, you know, you have to go as far as you are to get this resolved.
I'll be completely honest, I'm a huge fan of Costco. I like shopping there, but they are truly the worst neighbors you can imagine. We've gotten to the point where any complaint is retorted back to me in a very cavalier, and it could be any of the managers, some are good, some are bad, but they're very cavalier with the responses, saying things like, what did you expect when you moved next to a Costco? We've got the right to grow and make more money and grow as a business. And I understand that, I get it. I mean, you know, we're all business people, but not at the cost of our lives and our families and our peace in our backyards. I mean, it's just, there's 1,000 issues I could go on with you guys about, but this is the one we're here for today. But they're not good neighbors, and they're not really respective of, when I go to them with these issues, they literally just say, well, it's just the way it goes. There's nothing we can do about it. And I don't agree. I think there is something they can do about it. They can unload these trailers, increase their storage inside, whatever it may be. They've clearly realized they can sell more than they can store inside their store. And so as a means to sell more, they just park these trucks out and back, and that's it. They've got more stock on hand for as much as they can sell.
So as of July 3rd, Mr. Griffith made the decision that they were in compliance, but so right now, of course, you're here this evening, and we're looking at this to see who the right person was to make this decision, and maybe it was not Mr. Griffith. Should have been the zoning officer.
I agree.
And you stated that you did your homework, I got to tell you that. You had the right sections that you mentioned. So, any questions for this gentleman? Okay, is there anyone else speaking on this appeal?
Not that came with me.
No? Okay. Mr. Harris? No?
I would just maybe ask for clarification on when I just asked for clarification on when Mr. Delvecchio came into the office to look through the file.
Mr. Delvecchio, when did you come into the office for clarification that this was issued, that the compliance was okay? That Mr. Griffith had said that they were in compliance. When did you find that out?
I found that out, I'm going to say on, it was within 15 days of my application, so I tell you I could just go to that. So I came in to file this on August 5th of 2015. I believe, and I don't have the exact date here, but I believe it was late July, I want to say somewhere around the 25th. It was surprising because it was almost a year after the decision had been made, but no one notified me. And so as I called to ask the town attorney what's going on, that's when Stephen Harris informed me that this decision had been made. And when I asked what my options were, I was told I can file my appeal within 15 days of becoming aware of this issue, which is what I did.
Okay, thank you. Mr. Griffith is not here this evening to talk about why he made this decision, so seeing there's no one else to talk on this, I'm going to close this hearing. This hearing is closed. Thank you.
Thank you.
Comments, gentlemen and ladies? Who has the authority to make this decision? If you look at Section 822 lists the authorities who should be enforcing the regulations. It is the zoning officer, and if he's not around, the chairman of the planning and zoning, the city planner, the assistant city planner. It's not mentioned that a land use director would be making this decision.
It'd be nice to have Mr. Griffin here so we can ask him where he thought the authority came from that he could make this decision.
Correct.
In his absence, I assume we can still go forward with the decision about this. I guess that's a question I'm putting.
I would say so.
Based on the language of the regulation, it would appear that, at least based on this, that he would not have that authority. So,
Okay.
so I don't see what the gray area is here, but maybe somebody else does, or...
Any comments, Mr. Vecino?
No, I mean, I think that we base all of our decisions on the zoning guidelines book that we've been presented and that we've, consult at all times, and certainly it looks like an open and shut case that, the position that Director Griffith holds is not one that has authority over these enforcement of these regulations. So I also wish that he was here tonight to explain his position on that, but it does seem to be an open and shut case that unfortunately he doesn't have jurisdiction over this area.
Thank you. We need a motion. Should be to overturn the director's decision.
I think given the testimony that I've stated before during this discussion period, where I did not see the position listed in our zoning regulations, I make a motion to overturn the director's decision.
Second the motion.
We have a motion to overturn the director's decision. We have a second on the motion. Mr. Soto?
With the motion.
Mr. Vecino?
With the motion.
Mr. Haberman?
With the motion.
Ms. Fronte?
With the motion.
I'm with the motion. Decision overturned. Item number 3. Item number 3.
Item number 3, 247 High Street, SFA 10. Michael Goodman, agent for Nicholas Bate and Kerry Bate owners, various section 3-1-4-1. Front yard setback to 9.9 feet and 11.8 feet where 20 feet required. North side setback to 7.8 feet where 10 feet required. South side setback to 2 feet where 10 feet required. All to construct 2 buildings into one single-family home, map 65, block 321, parcel 26.
Good evening, sir.
Good evening, everyone. My name is Mike Goodman. My company is Goodman Building Company. As stated, I'm representing Nick and Kerry Bate at 247 High Street. I would like to pass out a letter that they sent with me. I will read the letter, and I have just a couple remarks. Ladies and gentlemen of the committee, thank you for hearing our appeal for a variance to allow the building of a mudroom connecting the detached garage to our main house at 247 High Street in Milford. Mudroom connection is necessary for safety reasons. We have a short driveway which is sloped down to the garage. In winter, dangerous ice patches form on the driveway and have already resulted in falls with injury 2 separate times since we have owned the house. Additionally, we have a 2-year-old daughter, Amelia. With our short stretch of driveway, she could very quickly run into the traffic on High Street after being lifted out of her car seat in the garage. Is it impossible for us, for one of us alone, to unload groceries or other items from the car when Amelia is with us? Because we have to maintain hold of her at all times while transitioning from the car to the house. The distance from our garage to the street is too short to serve as a barrier to her reaching the road. The proposed mudroom addition will allow us to enter the house directly from the garage with the door safely closed, keeping our daughter away from the potential harm of nearby traffic and preventing the slippery winter conditions of our driveway from causing further injury. Please give your approval for this variance, which would make access to the property safer for our family. With our thanks, Nick and Kerry Bate. I would agree that the driveway is very short and the buildings are extremely close. The house, I believe, was built in 1790. I'm not quite sure when the garage or workshop area was added on, but certainly that was a very long time ago. It's just very practical on what they're looking to do as far as connecting the 2 buildings. And basically, be able to go in the garage and, close the door behind them and not have to worry about, anything, whether it's the weather or having to keep the car parked outside and go inside. It's it's very common what they want to do. I was working on phase 1 of the project today, and one of the neighbors that got a letter in the mail came over and just stated that he was very happy that people were working on the house and putting the money into it, and he had no objection to the addition. This was just a verbal, he came over and saw me working and discussed this with me, but that's about all I have.
Okay, thank you. Any questions for this gentleman?
Yeah,
Can you tell me what the legal hardship is for this appeal, please, for this variance request?
Basically, considering the location of the buildings on the property, I believe they have an extra 130 feet to their back side, to their back line. And, I think the hardship is, they bought the house, the property a few years ago, and, they're trying to do the best they can with it. They like the location, being walking distance to the train. They have family in New York. They travel they take the train to New York a lot, and, they really want to make a home and stay there for a long time.
Right. I mean, I guess my statement is, if this variance request is going to be approved, it's going to be approved based on the merit of the legal hardship and not on the reason that there's a young child currently at the house. I mean, that passes in time, and this variance request that if we pass will go with the property forever. So, I think that's the argument that needs to be made here. So thank you for stating your hardship.
Okay.
I noticed that you're working on the garage. Are you, there's no increase into the garage or anything? You're just
No.
adding this breezeway? Because I
No,
noticed
this,
you're working
this,
on the...
this mudroom is going between the two buildings.
Okay, okay. I saw the wood there and everything. I thought maybe you're working on the garage
Yep,
itself.
no, we're straightening,
Straightening the line.
straightening the old building out. so.
Okay, all right.
Mr. Harris? Oh, I'm sorry. Go ahead.
And there's no living in, that's a two-story garage? There's a
It's a
space up
one-story.
top? Is
No,
it-
there's no space. There's some storage space, but no.
No living
living
space at
space.
all or anything? Okay.
Mr. Harris, all the variances stated here, but is the only reason that they're being presented is because this is being attached?
That's correct.
Could you speak towards where the placard was displayed so that people could see and have due notice of this variance request? Where was it on the house? Because I drove by several times and actually stopped, and I didn't see it, and that was Monday.
It was on the left side, in the large window, left side of the house.
It was nailed to the house on on this left side, right in
When
the
did you
house.
go there?
Today,
Today.
today.
Anybody go before today?
It was there Monday, last Monday.
Any other questions? Any other questions? Anyone else speaking in favor of this application? Anyone here opposed to this application? Any questions for this gentleman, once again? Okay, this hearing's closed.
Thank you.
Pre-existing conditions? Just closing it up, bringing it together, I don't see a problem with it.
I don't see a problem with either, and I think the property does have some hardships to it. I mean, it does topographically, it just slopes horribly down, and the house is right at the top where that slope starts, and it just sits there, so and again, anything they do in terms of connecting the house and the breezeway, they're not increasing any nonconformities with the house, they're just attaching, so it's not going to increase anything.
Thank you. We need a motion.
Motion to approve.
Second.
Reason for approval is the topography of the lot and the placement of the house on it. There's the hardship, and for the other reasons noted in the survey provided with the application.
We have a motion to approve. We have a second on the motion. Ms. Ferranti?
With the motion.
Mr. Haberman?
With the motion.
Mr. Vicino?
With the motion.
Mr. Soda?
With the motion.
I'm with the motion. It's approved. Moving on to old business. That's it, old business. Any old business? No? Okay. Any new business? Nope. Staff updates? Can we accept the minutes from August 11th, 2015? We need a motion to accept the minutes.
I read them, Mr. Chairman. I make a motion to accept the minutes from last meeting.
Thank you. All in favor? Aye.
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 Okay. Applications for next month, what do we have? Anything going on?
But I can't remember the address. Yeah.
Okay. Anything else? Motion to adjourn?
Second.
This meeting is adjourned.